Good morning, friends. In my last lecture class pertaining to the chapter number 1, I have covered meaning of contract and essentials of contract. All 11 points which are given under section 10 of the IC 1872 I have covered and I have very well explained. And I hope, friends, you must be liking this paper. You must be finding this paper very interesting because teachers play a very important role to make the paper interesting. One thing I would like to share with you, if you start liking or loving the paper, then the paper becomes interesting to you. It becomes easier for you. But if you treat it as a burden, you find that, what is this? That concepts are very difficult. I am not able to understand. Then you will treat this paper as a burden. You will not enjoy this paper. So I always advise my students, start loving, start liking the paper and enjoy. Then only you can enjoy if you start liking and loving the paper. So friends, after attending my first virtual lecture class regarding this chapter number 1, I hope you must have understood many terms which I covered in my last lecture class. So today is the second virtual class for the chapter number 1, which is meaning, nature and kinds of contract. Today again, friends, I am going to take up one statement. The statement is, the law of contract is not the whole law of agreements, nor is it the whole law of obligations. This statement has got two parts. The first part is, the law of contract is not the whole law of agreements. That is, what is agreement and what is a contract? You all know, friends, that the term agreement is wider as compared to the term contract. All those agreements can be termed as contract which possess the essentials which have been provided under section 10 of the ICA 1872. The law of contract is not the whole law of agreements. That is, all types of agreements, friends, they have not been covered under the Indian Contract Act 1872. The law of contract has got limitations because all agreements have not been covered under the law of contract. That is why the very first part of the statement is, the law of contract is not the whole law of agreements. There are a number of agreements like partnership agreements or sale of goods agreements, agreements pertaining to the negotiable instruments, or agreements for sale or purchase of immovable property. So before the enactment of Sale of Goods Act and the Partnership Act, Sale of Goods Act and the Partnership used to be a part of the contract of law. Section 76 to 123, they used to deal with the various provisions pertaining to the sale agreements. But after the enactment of the Sale of Goods Act 1930, we are having separate law pertaining to the sale of goods. Sale of goods, you all know, friends, it is concerned with the movable goods. And movable goods, we can put them under three categories: existing goods, future goods and contingent goods. Now regarding this classification of movable goods, I will be giving you details under the chapter relating to the Sale of Goods Act, which will be chapter number 14. And similarly, friends, the Partnership Act also. Before its enactment, it used to be a part of ICA 1872. But after 32, after it was enacted, now we are having at present separate act for the sale of goods and also separate act for partnership agreements. Under the sale of goods, there are 6 chapters, which I explained those 6 chapters in my introduction class to the Sale of Goods Act. Now, as far as Partnership Act 1932 is concerned, Partnership Act 1932 is not in the syllabi of BCom Honors Semester 1 under Delhi University. Earlier it used to be there long back, but now it was replaced by LLP Act 2008. But you all know a lot about partnership, friends. You all have studied this partnership, during your 11th or 12th standard. this partnership, admission of a partner, retirement, insolvency, then dissolution of partnership. Dissolution of partnership is different from dissolution of partnership firm. Minor partner. Can minor partner be admitted to the benefits of the partnership firm? Yes or no? If yes, then what are his rights and liabilities? So I mean to say, or regarding this partnership, who can be a partner of partnership firm? Duration of partnership, minor partner, rights and duties in case of admission, retirement, insolvency, dissolution. Okay, how is a partnership firm dissolved? Okay, so then all modes of dissolution of partnership, you all study under this Partnership Act 1932. You have studied a lot about partnership in your 11th and 12th classes. But this is not in the syllabus of BCom Honors at this time, but it was replaced by LLP Act 2008. And then similarly, Negotiable Instrument Act 1881. All agreements pertaining to the negotiable instruments, they have also not been provided under this ICA 1872. Bill of exchange, promissory note, and then check. Check may be of two types. One is open check and other is cross check. Inland bill, foreign bill. Okay, so all these types, friends, then check may be cross check or open check. And what is crossing? What are the different types of crossing? What is the meaning of dishonor? Which are the various modes of dishonor? Which are the various grounds on which bill may be dishonored? What is the meaning of date of maturity? And what are the rules regarding date of maturity? So all these, friends, you will be studying under the one has to study under the Negotiable Instrument Act 1881. And similarly, there's a separate act for the sale or purchase of immovable property. Even pertaining to that, the provisions have been provided under the Transfer of Property Act, Immovable Property Act 1882. So I have told you, friends, that the law of contract is not the whole law of agreements. All agreements have not been covered under ICA 1872. Now coming to the second part, nor is it the whole law of obligations. Now we all know Salmond has defined the term contract. Contract is an agreement creating and defining obligations between the parties. We know, friends, every contract creates obligations and rights. But we cannot say all obligations have their source in contract. Obligation may arise or will arise whenever the contract is entered into, but all obligations do not arise from contract. All obligations do not have their source in contract. And all those obligations which do not have their source in contract, I would like to discuss those under 4 heads. The first one is obligations arising from tort. TORTS, torts or civil wrong. If anybody does some wrong act, okay, then in that case, friends, if somebody has injured other person, or he has caused loss to the a car of another person, then it is his obligation. The law of torts throws obligation upon that person that he will have to compensate the other person who has suffered loss due to his wrong act. So wrongdoer is penalized. And there is no contract here, but the liability is there, obligation is there. And second, obligations which do not arise from the contract is status. For example, relationship between the trustee and beneficiary. Here also, friends, any trust which is created, it is for the benefits of the beneficiaries, maybe poor people or old people. But if the benefits, the trust doesn't work for the benefits of those persons, then there are obligations which will arise. And there's no contract here. Still, the obligations will arise. And the third type of obligation about which I would like to talk about, that is obligation arising from quasi-contracts. Quasi-contracts is a very small chapter, which is chapter number 9, which I will be discussing in my succeeding videos. So quasi-contracts, there is no offer, there is no acceptance. These are the obligations which have been created by the law. Now there are 5 sections. Sections 68 to 72, they deal with the 5 types of quasi-contractual obligations. Very first point, that is when the necessities are supplied to the incapable person or any person who is dependent upon such person, section 68. Second is payment made by interested person, section 69. Then section 70 is obligation of a non-gratuitous act, and section 71 is responsibilities of a finder of goods. And then the last point is when the goods are delivered or the money is given by mistake or the goods are delivered under coercion, which is section 72. So remember friends, these quasi-contractual obligations, 5 types which have been provided under section 68 to 72 of the ICA 1872. Now they are based upon the principle of unjust enrichment, which provides that nobody is allowed to enrich himself at the expense of another. So if any person has got any benefit from the other person, then it becomes his duty. He must pay for that. So friends, and the last point is the obligations which arise from the judgments given by the judges in the court of law. So judgments given by the judges, they are also binding. Nobody can say, no, I am not bound by this judgment. So they will also be binding upon the parties. So there is no contract here. Still the obligation will arise. So Sir John Salmond has rightly observed that the law of contract is not the whole law of agreements, nor is it the whole law of obligations. It is a law of those contracts, those agreements which have their source in contract. So friends, this is all about this in this virtual class. I hope you will like the content. Do like and subscribe to my channel, and so that you can get notifications of all my videos. Good, my friends.